Good afternoon. Welcome to Division 5 of the Court of Appeals. My name is Judge Furman, this is Judge Roman, and this is Judge Lichtenstein. We have two cases on the 1:30 docket. I hope I get the names pronounced correctly. People versus El-Howeris. Say that again, please.
El-Howeris is how I understand it.
Okay.
I will at least be referring to them.
Okay, thank you. And then Kuzava versus United Fire Casualty. Counsel here on that case also?
Yes, sir. Yes, sir.
All right. You should have been provided with a handout of our procedures. If anyone in the courtroom has a cell phone, please make sure it's off, and let's begin.
Good afternoon. Inasmuch as this court has already expressed interest in having two questions answered, let me start with the two questions. And I'd like to start with the second question first, because I hope to dedicate most of my time to the first question and all of the factual circumstances that surround that 404B issue. The easy answer to the second question is only Dr. Savage talked about the side effects or effects of Percocet directly. Our position is that the circumstantial evidence of Amin El-Howeris being out of it, being just there, coupled with his inability to walk without help, coupled with the juror's own experience. I know if it was something like fentanyl, maybe the jurors wouldn't be so familiar, but those are the facts I am relying on in the intoxication defense issue. There is no other evidence. Now, turning to the first question, that's really an intriguing question because the evidence that came in a really shocking way. In July of 2015, after significant argument and factual discussions, the judge ruled that the claims of several witnesses that Amin El-Howeris had a gun himself and pulled it and may have fired it, but it jammed, was either not relevant or, and I'm using the judge's expression, arguendo, if it had some relevance, that it was substantially outweighed by the danger of unfair prejudice. Then Iroka Guyton was acquitted. It's December. The prosecution seeks reconsideration of the 404B issue, but they don't even bring up the idea of defendant appellant having a gun, let alone that he discharged it, but it jammed. They didn't even try to get that back in. It wasn't until January 6th, the third day of trial, that the court on its own started talking about reconsidering that aspect of its order. What changed between July and January to change this substantially outweighed evidence that had only some relevance, if any, into motive, ill will? Those are the state of mind, those are the three bases that the judge gave. And I think I really need to focus on how much evidence came in on that. It wasn't just a couple of witnesses. It was a total of 5 citizen witnesses and 2 police officers. And they weren't just isolated questions. The prosecution and the trial below, they were skilled practitioners. They knew when they had a good piece of evidence, they could work it into other questions. So, for example, well, when you saw the man come up with a gun and attempt to fire it, what did you think? What did you do then? It was over and over. The witnesses, I guess in no particular order, are the listed victim, Mr. Omar, Elu Omar, that's number 1. Number 2 was Pi Hunter. Number 3 was Bruce Roberts, the last citizen witness in the case. Number 4 was Roderick Rubin. And number 5 was Lenny Lackenbat. That's 5 citizen witnesses. And although Elu Omar only was questioned initially about seeing an individual coming up with a gun and identifying him, the actual statement that came in through Rob McGregor, the Arapahoe County Sheriff's Office deputy, was that it jammed, that was used and jammed. So with one exception, and that's Pi Hunter, who only said that the man pointed the gun at him, this was brought up by a total of 7 witnesses. The other witness, other than Rob McGregor, was Cal, which is short for Calamar Gatchis, another deputy, who attributed Pi Hunter's pointing the gun at them. Why is that so detrimental? It's extraordinarily detrimental. And you need to look no further than the Supreme Court's decision in Perez to see that. Because what the Supreme Court said in Perez is that those types of detrimental, unfair, other crime evidence has a tendency to let the jury convict the defendant on the basis of other prior acts. And we know that the jury struggled with the role of defendant appellant in this case. They were out for 2 days. They sent out multiple questions about complicity and about accessory and wanting to know the details. What swung the scales of justice towards conviction in this case was the simple fact that if they believed these multiple witnesses who claimed that Amin El-Howeris himself had a gun and attempted to discharge it, then that means that he tried to kill El-Omar 2 days earlier, and so maybe it doesn't matter. If we can't really find complicity beyond a reasonable doubt, we can rely on the fact that he attempted to commit the same crime 2 days earlier. Now, I don't want to...
I'm sorry to
please.
interrupt, but was the jury instructed and their consideration limited that they couldn't consider it for the improper purpose?
What the jury was instructed is they could consider for improper, let me get it right, state of mind, improper motive, ill will. Those are the three things the judge instructed on. And just the fact that he was in a fight with El-Omar and was then shot 4 times, I think more than adequately demonstrated motive. As the trial judge himself recognized, to go further and talk about some witnesses claiming that the defendant appellant himself had a gun, I think that goes a step way too far. And so it doesn't really matter what the jury was instructed, because what they used it for was evidence of prior criminality. It's clear from the way the jury struggled with the case as the case went on.
Well, sorry to interrupt. In context, it seems to me to be a bit of a classic retaliation, right?
I'm sorry?
Retaliation.
Oh,
Omar
absolutely.
shoots, and then 2 days later we have a misguided homicide.
Right.
So the context of the party seems to be laying the foundation for the idea that this is a retaliation crime. So help me understand how if somebody gets shot and they have a gun, they're going to raise it and try to shoot back. That just seems like a response that people might do if they carry guns. So how does that sway?
Let me explain first. Retaliation was adequately established. The idea of revenge and retribution was completely established by the very fact that they were in a fight and he was shot and he believed it was El-Omar.
Okay.
That establishes that motive. Why go further? And one of the things that the question we were asked presupposes is that it was return fire. When you actually read the transcript of what was said, no witness ever said that he pulled the gun out after he was fired on. So it remained completely open to the jury to conclude that it was Amin El-Howeris who pulled out a gun and attempted to fire the first shot. I know that's not what the question said. And all I can say is that when you read the record in a non-adversarial way, as I am forced to do, it could be the jury thought he attempted to fire first, which would have justified his being shot by El-Omar, which makes it all the more prejudicial. Because as the trial court recognized, there was more than ample other evidence to demonstrate that retaliation type of argument. Other questions on that particular issue? I will bring up just another point. When Lenny Lackenbach, the barber, was being asked about what Roderick Rubin told him, a prior statement attributed to Lickenbach was that Roderick Rubin told him that Amin El-Howeris had a gun and attempted to fire it, but it jammed. But on the stand, he didn't remember making that statement. When the prosecution went to ask him about the prior statement to Deputy McArthur, They used it to try and show that Lickenback feared retaliation himself. So they were able to use this alleged attempt to shoot by Amin El-Howeris for two things. Number one, to establish, again, the prior attempt to kill, at least according to some witnesses. And secondly, to attempt to convince the jury that the reason Lickenback wasn't remembering was that he was fearful. Other questions on that issue?
How do you deal with the harmlessness argument in this case?
Well, you know, I don't think I've seen an appeal recently where I haven't seen the claim that the evidence was overwhelming, that the whatever it was harmless. But aside from that personal remark, all I can tell you is this: the jury didn't find this harmless because the jury struggled with complicity. The jury struggled with what role Amin El-Howeris had in the Arapahoe Green shooting. And you can see it from the fact they were out for 2 days and they sent out notes. Those speak for themselves. So although you can say, well, it was overwhelming evidence, even without an involuntary intoxication instruction, it's clear the jury was struggling with how to deal with the fact that a fellow who was so out of it, who was just there, was criminally responsible, culpable for the actions of others. So that's my answer to the harmless error. It wasn't harmless at all. I have 4 minutes and a little left. I'll maintain them if I can.
All right.
Good afternoon. My name is Glenn Roper, registration 38723 on behalf of the people of Colorado. I'd also like to begin by addressing the two questions from this court's recent order. I think as to the first issue, the shooting at the party, I think defendant generally concedes that evidence about the party, the fight, and that he was shot are all admissible, and that he challenges only this evidence about him having had a gun at the party, Mr. El-Howeris having had a gun. And I think that my colleague on the other side overstates the evidence that was introduced with respect to this. The prosecution asked 4 individuals who had been at the party about it, and each of them denied that the defendant was there and had a gun. This evidence was only introduced through impeachment of 3 of those witnesses through law enforcement who testified that the individuals had stated had earlier stated that defendant did have a gun, and that as to a couple of them, or at least as to Mr. Rubin, that he had tried to fire it and that it had jammed. Now, the trial court did not abuse its discretion in allowing this evidence. It was used primarily for impeachment. To the extent that it was used substantively, it was not to show the defendant's character, but to show his ill will towards the victim and to show his motive and intent to cause the victim's death. And Colorado courts have held that in a murder prosecution, prior threats or acts of violence toward a victim are admissible for these very purposes. I think it was also important for the jury to understand defendant's actions at the party where he was shot and which directly led 2 days later to the murder that is for which he was convicted. Now, I'll concede that the evidence about him having a gun arguably paints him in a slightly worse light than if he was just involved in a fight, but I don't think it was unduly prejudicial here because the evidence was very limited. It was introduced only in impeachment, and it did not add significant prejudice where there was already evidence that he was involved in a fight, a vicious fight, where there was testimony that both men were bloodied coming out of this fight, and guns were involved. Guns were used in this fight. So the fact that it was limited, used in impeachment, did not add significant prejudice, and the court provided a limiting instruction every time evidence about the shooting came in. It was not an abuse of discretion for the court to allow this testimony.
Let me follow up with this. So the jury was allowed to consider it substantively as well as just for impeachment. You agree with that?
Certainly, Section 1610-201 allows substantive use of impeachment evidence when certain requirements are met. The prosecution never argued that, but in their closing argument, they did refer to him having had a gun, apparently in a substantive way. So I probably could not say that it was solely used for impeachment. Unless there are further questions on that first question, I'd like to turn to the court's second question in its order. And I think as my colleague has conceded, the answer is unequivocally no. There was nothing other than Dr. Savage's testimony about the side effects of Percocet. And in particular, there was no evidence that Percocet can cause intoxication or an inability to follow the law. Now, the defense had endorsed an involuntary intoxication expert who conceivably could have offered that opinion, but they did not call him at trial. And Dr. Savage, who was the attending emergency room physician for Mr. El-Howeris, testified only that Percocet could cause nausea or perhaps drowsiness, not that it can cause intoxication or that it can make someone unable to be complicit in a crime by encouraging or assisting others. In that same vein, there was no evidence as to the timing of Percocet, how long side effects would last or when they would kick in. And these, I think, are fatal flaws to the involuntary intoxication defense. There was another factual problem with that defense, and that is there was no testimony that defendant ever took the Percocet. His friend, Ms. Abdul, testified that he had asked for some juice to take a medication, but she didn't know what the medication was. She didn't know whether he actually took it, and she testified that it was not on Christmas, the day when they were at her apartment planning the murder, but it was on another night when he asked for the juice to take the medication. So without some credible evidence that he took the Percocet, when he took it, the timing of any side effects, and that Percocet can cause someone to be intoxicated or unable to conform his conduct to the law, there was really no basis for the jury to be able to find involuntary intoxication here. If there are no further questions on the court's second question, I'd like to go ahead and turn briefly to the evidence of the gang-related evidence issue and make three quick points there. First, the prosecution's theory in this case is that defendant and his gang, in retaliation against a rival gang, murdered an innocent bystander and attempted to murder a member of the rival gang. Introducing gang-related evidence was the only logical way to present that case and to test the prosecution's theory, and the trial court did not abuse his discretion in allowing it. My second point is that it's significant here that the trial court did not just let in everything about gangs. Instead, he excluded some gang-related evidence that the prosecution sought to introduce. And I'd point the court to the trial court's order on page 263 of the record, where he kept out evidence of a drive-by shooting between the rival gangs, evidence that a member of defendant's gang was assaulted by the rival gang about a week before the shooting, and then evidence that a member of defendant's gang actually shot at Mr. Omar, at the victim here, a couple of months outside of a bar, a couple of months before the murder here. So the court made reasoned judgments about what gang-related evidence was relevant to defendant's case. The court also gave appropriate limiting instructions anytime there was gang-related evidence introduced, modeled after decisions by divisions of this court in People versus Martinez and People versus James. And then my third point on the gang-related evidence is that defendant relies on Trujillo, an opinion by Judge Furman. But Trujillo, I think, actually undermines his case because although he argues that nothing should have come in about gangs, the word gang should not have come up in trial. The Trujillo court actually approved the admission of extensive gang-related evidence, including under 404B to show motive. Also, Trujillo is distinguishable because in that case, there was no evidence that the victim was a member of a rival gang, so you didn't have the retaliation aspect that was key in presenting the evidence in this case. What Trujillo kept out was evidence that had no connection to the charged crimes, and then some evidence that was found to be cumulative about penalties imposed by gangs for talking to the police. Here, the gang-related evidence was relevant to show motive and to show the circumstances of the crime. It was also relevant to explain to the jury why some witnesses had apparent memory lapses or were unwilling to share their testimony. That included, actually, the victim, Mr. Omar here, who freely spoke with the police in interviews, but then at trial denied being a member of the gang and claimed that he had never even seen the defendant before in his life. And there was good reason to think that this changed testimony or reluctance to testify was related to the gang issue. If there are no questions on the gang-related evidence, I'd like to briefly address the cigarette store robbery. And this, to put this in context, so you had the party where Mr. El-Howeris was shot. That was on December 23rd. A couple days later, you had the murder. And then about a week after that, you had the cigarette store robbery. And with respect to the cigarette store robbery, there's really no 404B issue at all, because there was no evidence there with respect to defendant's actions or his character. Instead, the evidence was introduced there to show how the police connected defendant and members of his gang to what until that time had been an unsolved murder. Through a gun that was found at the scene, ballistics testing of that, and then through evidence that was found in the getaway car, they were able to connect defendant and members of his gang to the murder. The prosecution never stated or implied that defendant was involved with the robbery. It was 3 other individuals who had been connected to his gang. Now, his medical ID bracelet and medical prescription were found in the getaway vehicle, and that's how they were able to tie him in. The court gave proper limiting instructions as well with respect to evidence about the cigarette store robbery. Now, the defendant in his brief talks about him having offered a stipulation as to the finding of the gun, but that would have been insufficient here because it wouldn't have explained the connection of the defendant to the cigarette store robbery and eventually to the murder. It would have left out all the information about the medical ID and prescription bag. Even if it's possible to have come up with some sort of stipulation that would have covered all of that evidence, the defense never offered it here, and the trial court certainly isn't required to try to come up with a stipulation for the parties. If there are no further questions,
Can you tell me why the case is harmless? This is assuming, of course, that we would disagree with you on
sure.
one of the underlying.
No, I do think that any error as to the issues brought up by the defense would still be harmless in this case. He talks about the jury having taken a couple days. They did take about a day and a half in deliberations. They did ask some questions, but there was nothing to indicate that they were struggling to reach a verdict. Their questions were all simply trying to understand the instructions. I think that shows that the jury took it seriously and that they performed their duties as they were supposed to.
What's your overwhelming evidence when you remove the evidence of the gun, jamming and so forth, if that's not part of the evidence in the case?
Sure. I think that's actually a very limited piece of evidence. The bulk of the evidence that I think is relevant here has to do with the Christmas Day meeting, where you had defendant Mr. El-Howeris at a friend's apartment. He called his friends there. They all joined in. He said to his friends, "Look at what they did to me." They, not just referring to one individual, but they talking, the gang connection there. There was a gun that was passed around. There was evidence that he then joined with the other members of his gang. They went in the car. I don't think that he disagrees that he got in the car and drove to the crime scene, and then was there and present and complicit in the murder that happened. If there are no further questions, this was a tragic case, but the trial was fair.
I do have one more question. I'm
Oh,
sorry.
please.
Was there evidence that somebody at the house said something to the effect of an assault on one of us is an assault on all of us? Or was it?
Yes. Yeah. I don't remember the exact words, but something like what you do to one of us, you do to all of us, referring to the gang, the Sick Maid gang.
And were they only gang members that were in the house, or were there non-gang members in the house as well? Do you know?
There were 2 women who were not gang members, both of whom provided testimony in court, and one of whom gave extensive testimony about what was said, and that's where that evidence came in about what Mr. El-Howeris said and what the others said, as well as the gun being passed around.
Thank you.
If there are no further questions, we would ask the court to affirm on all issues. Thank you.
I know your question addressed the solely for impeachment theory, which doesn't hold water, but it goes further than that. By the time the case got down to the final citizen witness, Bruce Roberts, it wasn't even a matter of asking Roberts didn't you tell Officer MacArthur or some other officer this? They just said, are you saying that he didn't come up with a gun and try and fire it and it jammed? It was being assumed as truth by the prosecution at that point, and it was argued as truth by the prosecution during closing. Indeed, the defense had to concede, even though they'd fought the admission of that evidence, that there was witnesses, although they erroneously said one, who said that he had a gun. So my position on this is that this is a real-life trial. This is not some abstract theory of impeachment versus concrete evidence. It was argued as fact and given to the jury as though it were fact. Turning to the gang issue, I think the whole idea that this was a gang case, it may be the theory of the prosecution, but you got to have the evidence. And there was scant evidence that this was a gang-related case. It did not involve retaliation by groups of one gang against another gang. This was personal. This was personal retribution for what happened to their friend at a party. And to point to 2 times where, look what they did to him, or look what they did to me, or in this case, what they do to one of us, they do to all of us, that doesn't demonstrate a gang connection. But the idea that the gang evidence was limited, oh my, that's just simply not supported by the facts. This case is governed by Trujillo because we had beating in, we had retribution, we had commission of crimes to get more status, moving up in the gang, colors, tattoos, throwing signs. What did any of that have to do with establishing what was Amin El-Howeris' state of mind at the time when his friends went to seek revenge for what happened to him? And the answer is easy. It's not. We had a full morning of a very competent gang expert, Kevin Rossi, talking about things that had literally nothing to do with the case. And we had the same situation in Trujillo where jury members expressed some concern. Should I be worried about wearing my Colorado Rockies hat? Because now I know maybe that means Crip. Certainly by the time this case was tried, most citizens of the United States were well aware of the idea of Bloods versus Crips and gang warfare, and rightfully being afraid of that. And this was exploited, in this case, unfairly, by turning what was really a personal retribution against one guy, one person for what he did, not his gang, into a gang case. And that's really how it was tried. I forget the numbers, it's in my brief, but 8 witnesses, 10 witnesses testifying about gang, every citizen being questioned about gang connections. This trial was not fair. It was not fair because gang evidence came in. It was not fair because improper evidence was admitted under 404B, evidence that the trial court itself recognized had little actual probative value and substantial danger of unfair prejudice. I would ask the court to reverse the conviction accordingly. Thank you.
Thank you, counsel, for your excellent arguments. The case will stand submitted and a written opinion will issue in due course. Whenever you're ready, let's get started.
I think someone's. Good afternoon. Good afternoon. May it please the court. My name is David Yoon. My registration number is 23448, and I have the privilege of representing the appellant, United Fire and Casualty Company. There are two issues on appeal. One, whether United Fire should have been allowed to intervene in a lawsuit between the plaintiffs and its insureds when they entered into a type of non-agreement. Second, if this court were to find that United Fire had a right to intervene, whether the arbitration award and the judgment should be vacated because they were entered without United Fire's participation. As this court knows, it reviews the denial of a motion to intervene as of right de novo. Under Rule 24A2, 3 requirements must be satisfied. 1, did the applicant claim an interest in the subject matter of the lawsuit? 2, will the disposition of the lawsuit impair or impede the applicant's ability to protect that interest? And 3, would the applicant's interest be adequately represented by existing parties? It's important to keep in mind that the trial court never actually ruled on the merits of our motion to intervene or applied the 3-prong test. Instead, what the court did was the court waited 1 year and 2 months for the motion to be pending, and after it entered a judgment on the arbitration award, denied the pending motion as moot. So I want to go through the 3 prongs and address each one of them. So plaintiffs argue that under the first prong, the interest was not sufficient because there was a reservation of rights letter, and there are 2 responses to that. One is factual and one is legal. Let me address the legal response. There is no reported Colorado case holding that a reservation of rights letters makes an insurance company's interest insufficient under Rule 24A2. Instead, what Colorado courts have repeatedly said is as follows. The existence of an interest should be determined in a liberal manner, using a flexible approach, and should not be viewed formalistically. When determining whether intervention is proper, the court examines only what interest is claimed, not whether the intervener will be successful in litigating it. In this case, under this liberal standard, United Fire clearly claimed an interest in the subject matter of the lawsuit. Plaintiff asserted that Lion Trucking and its driver are responsible for damages caused by the car accident. As the insurer for Lion Trucking and its driver, United Fire is responsible for any judgment covered by the policy in an amount up to the policy available limits. So consequently, United Fire has an interest in the outcome of the tort litigation. And moreover, we cited to some of the out-of-state cases, mostly in Arizona, which have held that when the insured enters into a type of non-agreement with the plaintiffs and the insurance company still continues to defend, regardless of whether it reserves its rights to deny coverage, there is sufficient interest to intervene. In this case, it's undisputed that United Fire defended the Lion Trucking Company and its driver, even after the non-agreement was entered into.
Did they reserve the right to coverage, distinct from duty to defend?
I would submit, Your Honor, first is the legal argument, but factually I do not believe so, for a number of reasons, and I'll address that. I think they're mistaken about the reservation of rights. When the original complaint was filed, asserting a negligence claim and loss of consortium, United Fire defended Lion Trucking and the driver without any reservation of rights. Only when the amended complaint was filed, adding a fraudulent transfer of asset claim and piercing the corporate veil claim and adding LC Trucking, which is not even insured under the policy, United Fire sent the reservation of rights letter. And that reservation was only related to those new claims that were asserted. And case law is clear, when an insurance company accepts coverage for any negligent conduct while denying coverage for intentional conduct, there's still a direct interest in the liability lawsuit. That's because the insurance company is still at least partially liable for the covered claims. And therefore, a partial reservation of rights letter for fraudulent transfer and piercing the corporate veil did not make United Fire's interest contingent. And more importantly, even assuming, the December 10th letter, by the way, we don't actually have the reservation of rights letter in the record. Even if, assuming that the December 10th letter, which counsel cites, somehow reserved the rights. I would submit that it was actually reserving the rights related to the new claims. But even if you assume that, United Fire's subsequent position clearly established sufficient interest. Subsequently, we filed a pleading that acknowledged that it was contractually obligated to cover any judgment against the named insured and its driver for bodily injury arising out of the subject accident up to the available policy limit. So because United Fire's subsequent admission constitutes a judicial admission, United Fire clearly satisfied the first requirement.
Let me just follow up. As a factual matter, the reservation of rights letter, you're saying it was limited to the new claims. Was it limited to particular defendants, or did it apply to all defendants?
It did not cover LC trucking, which is not even part of the arbitration award, but it provided a courtesy defense throughout the whole case. And during the arbitration, only claim that was submitted was the negligence claim and consortium claim, and that's the basis for the arbitration award.
All right, because my understanding, looking at the letter, it says any claims, it was pretty broadly worded, so.
Yes, and if you look at the letter, a lot of it's redacted. I would admit to you there's boilerplate language, but if you read the context of it, I would submit that they were reserving the new claims. And we know that because when the original complaint was filed, there was no reservation whatsoever on the negligence claim and loss of consortium. It only arose later. And to the extent the court thinks there's some sort of factual dispute, which we don't think exists, but to the extent there is, it should at least remand for the court to determine that factual dispute.
Mr. Yoon, I know your time's limited. I'm interested in your second issue on
Oh, sure.
arbitration and whether it should be vacated. Would this be a good time to switch
Yeah,
to that?
I'll jump to that. So the next question is, if the court concludes that United Fire had a right to intervene, what happens to the subsequent arbitration award and the judgment? We submit this court has to vacate the arbitration award and judgment because they were entered without United Fire's participation.
And do you have authority with the exact set of facts?
Not
just
the
sort
exact-
of the broad concept, which I know I saw your authority on that, but authority where there was an arbitration on the one hand, because I see a tension here, and a motion to intervene that was granted on the other hand. And do you have authority that says because they didn't grant the motion to intervene, the arbitration is vacated?
There's circumstances where they enter into a non-agreement and arbitration is very rare. I'm not aware of any case on point, but what the Colorado Supreme Court did say is in Cherokee, we believe that case is on point because what the Supreme Court said was it vacated the declaratory judgment, which was entered after the trial court erroneously denied the motion to intervene. And the Supreme Court did not require the intervener to demonstrate that it was substantially aggrieved or to establish some sort of standing. What it said was, it concluded that the declaratory judgment has to be vacated because the intervener has a right to be heard before the judgment.
And I was wondering about that too, what it means to be heard. So let me back up just a second. If the trial court had said, I'm going to give a United Fire a hearing as it requests, and I'm going to grant it as an intervener, but I'm still going to keep arbitration as the venue, would we be here today?
The court never heard our objection to the change of venue, and we laid out some of the arguments in our brief. So I would submit to you, Your Honor, as the Supreme Court said, it's what interest is being claimed not or whether or not we will be successful. And it would be inappropriate for this court to prejudge a motion that the trial court did not even consider. Because what the trial judge did was sat on the motion to intervene for a year and 2 months and then denied it with moot. So the court never heard the argument regarding our objections to change of venue. So what I think the Supreme Court is saying is we're not going to prejudge all these arguments. We're going to remand it for the trial court to make a determination whether or not we have a valid objections. So we would submit that we have a right to be heard on whether our objections to the change of venue and arbitration is successful. We have a right to be heard on Lion Trucking and its driver's liability. And we have a right to be heard on the validity of the agreement entered into between the plaintiffs and defendants. I don't think the question before this court is whether it would have prevailed on these issues. The question is whether we have a valid interest in the litigation. And
I see, and I'm just trying to, I didn't mean to interrupt you, I'm sorry.
so that's what the court should have ruled on the motion to intervene. And if the court allowed us to intervene back in June, I forget the year, but June, then we would have raised our objections. But what the court did was set on it, and we don't even know what the court would have ruled. So I think the court has to vacate the judgment and the arbitration award. And if the court concludes that we should have been allowed to intervene, allowed us to participate and raise those objections for the trial court to make a determination whether or not the arbitration should go forward or not, whether we have right to raise defenses in the arbitration or not, and those
So
kind of
it would
things.
be a brand-new arbitration,
Yes.
potentially? Because I'm just trying, the tension that I'm having is, I'm trying to find the authority under the Uniform Arbitration Act for reversing the arbitration award. And so I was hoping, and that's what I was asking you about, authority, where we had this scenario, and in this scenario with the intervention, they reversed the arbitration award. That's what I'm struggling with.
Well, as I mentioned in the brief, one of the things is if you're going to arbitrate and we have a right to intervene, all parties have to agree to arbitrate. And we didn't agree to that. So if the court says you had a right to arbitrate, you have a right to intervene in the lawsuit, our argument will be that we have to agree to it. But that issue hasn't been decided. I don't think it's appropriate to prejudge what the trial court's going to rule.
Thank you.
So that is our position. So for all those reasons, we ask the court to vacate the judgment and allow the United Fire to intervene. Also-
Mr. Yoon, before you go on, I do have a question. Okay, let's talk about the timing of the court's denial of the motion as moot, and what was the reason for it being moot, and can you address that?
It's not clear why the court found it moot, because what we do know is that what you're asking, why the trial judge found it moot?
And your position on that?
Well, the trial judge didn't specify why it was moot. The trial judge's clerk relayed a message by email saying that it's moot because of participation in arbitration. United Fire did not participate in the arbitration. And counsel will tell you that he invited United Fire to participate. And there's two problems with that. One, we had, first of all, he never withdrew his objection to the motion to intervene. So even though he sent a letter saying you could participate, he never formally withdrew the objection. Two, he didn't specify what rights we have in the arbitration, what we could object to, how we could participate. So that was never clearly defined. Three, the invitation did not include our prior objection to the change of venue and the waiver of jury trial and the waiver of appellate rights. So if by participating from an informal invitation, we would be waiving all of those rights. So so we would submit that we didn't have to participate. But the trial court did not explain why it was moot. I will save 24 seconds, Your Honor, for rebuttal.
Good afternoon, Your Honors. My name is Mark Levy. I'm here with Jeff Boxer, and we are here representing Mr. and Mrs. Kuzava. Mr. Kuzava is also in the chambers with us here. My theme for this entire appeal, this entire argument is waiver, 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 and intervene to do what? And Your Honor, I've just heard a whole lot of stuff about intervening for the purpose of stopping two parties who are willing to arbitrate. I've never heard of such a thing. And it sounds very much like United Fire is advocating a direct action rule against liability insurers, so that when you sue the insured, you must then also include the insurance company. And the question is why? Intervene to do what? So what? Because I do want to answer a couple of questions here. First, about this reservations of right issue. This case is unique from every other case that has sort of addressed this. And as United Fire has noted in their brief, there is no case directly on point. This is kind of a really important public policy point of how do you affect the public policy set forth by the Colorado Supreme Court in the Nunn case, which on its own was about 40 years in the making. This particular issue has been, we're almost on 50 years now, going all the way back to the Northland versus Basher case. But at paragraph 11 of United Fire's complaint in intervention, this was the complaint that was denied, and this is at the record 321 and 327, United Fire says, quote, since the outset of this action, United has defended Lion Truckin' Inc., Eric Cubby, and Lion Chavez under various reservation of rights letters, which is something different than what Mr. Yoon just represented. Now, we don't have all that because, of course, as the plaintiff's attorney, we would not get these reservation of rights letters. And so, there's only one in the record, but we do have this admission at paragraph 11 of their complaint in intervention. So, intervene to do what? Well, and in addition to the reservation of rights, Mr. Yoon said there is some pleading where they have admitted that they owe contractually, apparently up to the $840,000 of the liability limits. That's never been represented to us before, and again, that's something else that is unique about every other case that has addressed this, is that there has been no concession by United Fire here that they even owe that. And in fact, we are sitting here 5 years, 2 weeks, and a day after the automobile accident in this case, where my client got rear-ended by a loaded dump truck, Kenworth dump truck, $300,000 in bills, and United Fire has not paid a single penny for the liability exposure that they contracted with under their liability policy. So to say that they acknowledge that is, I think, a little unusual. So the other thing Mr. Yoon mentioned is that there was an informal offer to participate, and this gets to my question of both waiver and so what? They had the opportunity to come and do it. First of all, I'm going to tell the court I completely reject the idea that a liability insurer can intervene in a case for the purpose of stopping the two parties of doing an arbitration. Arbitration is favored in Colorado. The liability carrier has no right to do that. And the other thing about this whole intervention as a matter of right, under the principles established, is that there is some alternative forum for them to address their issues, then intervention should not be allowed, and they should not have an intervention of right.
So, Mr. Levy,
Yes,
can you answer the question that I asked Mr. Yoon? Are you aware of any authority recognizing the unique facts in this case where a party was allowed, where the ruling was it should have been allowed to intervene, and then what happens to the arbitration that took place with the other two parties?
No, other than, I think, 50 years of Colorado jurisprudence says, as Judge Gannett did, that when two parties agree to arbitrate, they're allowed to do it. Now, if United Fire wants to argue about the consequences of that, that's a whole different story. But, Your Honor, I'm going to tell the court I don't think there's any authority that allows this court or Judge Gannett to set aside the judgment in the arbitration because the liability carrier wasn't a party. There's no requirement in their policy. There's no statute. There is no public policy that should allow a liability carrier to do that unless we're going to have a new rule of direct action against liability carriers.
Well, let me
Yes,
ask you this. Assume for the purposes of this question that we were to conclude that they should have been allowed to intervene. If that's the assumption, if the district court does not vacate its prior order regarding the arbitration at that point, What's the value of the right of intervention?
The value of the right to intervene is to attend and participate in the arbitration. Now, this gets to then again, going back to the complaint in arbitration, the complaint in intervention, there are only two, this is one thing I want to point out here, is that we're not talking about these broad principles, we're talking about what United Fire did in this case. And for what I'm hearing today, if this is what they were intending to accomplish, they did not go about it procedurally the correct way. They filed a complaint in intervention. That's the motion to intervene that we're talking about here, is to allow this complaint to be filed. Has two claims for relief. One is for a temporary restraining order. And again, are there any factors upon which the liability carrier could have come in and done a TRO? They didn't even try to do a TRO. Any irreparable harm with respect to other parties going through and arbitrating a case, which our Colorado courts have said over and over and over again is a favored method of dispute resolution, specifically including with insurance companies, and we cited the Brecky case for that. So they've asked for 8 different things. Of all of these 8 things they asked for, and this is again at the record 321 and 327, this is page 5, the only one that they could remotely be entitled to is declare that United is entitled to provide a full defense of defendants against the plaintiff's alleged claims and damages. There's 2 things we know about that. Number 1, United Fire did. United Fire hired lawyers, Cheryl Anderson, you've seen her name in this, and came in and did a full-throated defense. Every word of it was on the record, was recorded, and Judge Briggs gave the defendants with counsel hired by United Fire, controlling that defense all the way through, every right to present all of their evidence. They presented all of their liability witnesses, they presented their liability experts, they presented and did vigorous cross-examination, and all of this, again, is recorded over 6 full days of arbitration. It went on for like 8 or 10 hours a day.
Well, Mr. Leafy, let me just ask you, was there representation of the insureds? Would that be limited, and would their representation possibly be different if they were to defend in their own name?
There was no limitation to the defense to be provided, and I understand some of these things are done with some kinds of conditions put on the arbitration, like we're going to stipulate the liability, or you're only allowed to call these witnesses. None of that was done here, and you can look at the arbitration transcript to see that. But they were given full, and what Judge Briggs said is, we didn't want it stretched out so many months, as it turned out. And Judge Briggs said, no, I'm going to allow them to present whatever evidence they want, and if we have to schedule more days, we'll schedule more days. So there was no limitation at all, and we have to presume, I think it's a legitimate presumption, inference that since they were controlling the defense, United Fire, in fact, controlled the defense. But to go back to this argument of waiver, and so what, I'm going to ask you to look at my letter of, it's at the record at page 93, CF 93 and 94. And this is not just, you are invited to come to the arbitration. This is June 1, 2016. It was before. You heard Mr. Yoon say that we hadn't withdrawn our objection to their intervention. We told them they didn't need to intervene. We told them we would stipulate to them intervening in the arbitration process. June 1, 2016. I said, please note that the agreement to change venue does not in any way impair defendants, or for that matter, United Fire's right to present a defense at trial, and contains no admissions by your insureds, et cetera, et cetera. And at the bottom of that, I said, United Fire is, of course, welcome to attend and present pertinent evidence as it deems appropriate. In fact, our clients are willing to waive any formal requirements for United Fire to intervene, and instead simply stipulate to same. That was June 1. That was before a intervention was filed, and we don't know why United Fire didn't file an intervention as to that point. And I got a response on June 7. And this is Exhibit 3. This is at the record, page 95 to 96. It says, United Fire is not a party to the 3-day arbitration and will not participate in its own name, as it will not agree to be bound by the outcome of the hearing or waive any rights to contest the venue, selection, or fact finder of that procedure. Now, again, those were not conditions of my invitation, my agreement to stipulate. So again, the law never requires parties to do things that are useless, that are worthless, that are of no benefit. And here, you don't have to have a formal order of intervention to participate in the arbitration. What we've now heard, I think, is an ulterior motive that was never, ever disclosed in any of the pleadings or presented to Judge Gannett, and that is we wanted to stop the arbitration from happening, and if we were allowed to intervene, we could then come in and say, we could stop the arbitration because we're now a party and we never agreed to the arbitration. But that was never disclosed, it was never argued, and it was never put before Judge Gannett. Yes, ma'am.
So what is your position that what they're saying, they're prejudiced essentially because they did not, they weren't able to argue that they had a jury trial right or a right to appeal that they wouldn't have had in the arbitration?
Well, we know that they don't have any jury trial right. No party has an absolute right to a jury. Juries are waivable in Colorado. It's not a constitutional right like it is in the federal constitution in certain cases, et cetera. But what they chose to do after we agreed to stipulate is they then voluntarily chose for tactical reasons not to participate in the arbitration, to accept the stipulation, to accept that stipulation that they could come and participate in the arbitration, but they did anyway. Remember the practical effect, because the practical effect is they gave a full-throated defense, as they would in any trial scenario. And, Your Honor, I think you get to one thing that has just irritated United Fire is they didn't get a jury trial. But again, there's nothing in their policy that says we'll only pay a judgment if there's a jury trial, and the parties are free to waive a jury trial. But there were otherwise, this was an unconditional offer. And so for that reason, we don't think this is just harmless error. We think this was invited error. And in fact, because of United Fire apparently trying to do something clandestinely tactical here, this was created error. And so when we look at the appeal in this case, and Judge Gannett's order on this case, it was in fact moot because United Fire had every right to, quote unquote, intervene in the arbitration and present any defense it wanted. And again, if there's an alternative forum, which there clearly is, we have a case going in federal court where United Fire has denied coverage. But honestly, I welcome United Fire's request that this court rule, well, one way or the other, on vacating the judgment, because there are absolutely no grounds under this set of facts where the liability carrier gets to have that standing. They don't have standing to ask that to do. And then, if there's a reservation of rights, and there is no concession with respect to we're going to have to pay the contract limits anyway, it does in fact make their interest contingent. And again, Colorado law is clear that if their interest is contingent, they again have no right to intervene.
Mr. Lee, let me follow up. When you were saying there is an alternative forum, the bad faith claim or the contract claim, are the issues different there than the issues in the underlying negligence case, and would that make a difference?
It would make a difference because the issues are different, and they have they've had all kinds of alternative forms. They could have filed a declaratory judgment action anytime they wanted since June of 2016. We're now in 2018. Why didn't they do that if this was what they were trying to do? And I also want to comment on, they did respond to the Uniform Arbitration Act, our motion to enforce to have the arbitration entered as a judgment. They did respond to that. They did not ask to appear. They did not ask to intervene at that point. They said to the trial court, you should wait 90 days before you do this, and the trial court did. But in that 90-day period, where under the Uniform Arbitration Act, any such objections should be made, United Fire elected to voluntarily remain silent and do nothing in that process. And again, it's kind of hard to know exactly why. So United Fire has all along had an opportunity, a full opportunity, to participate in this in a full way. And under the right to intervene, the three factors have not been met. There was no non-contingent interest because there's no concession, and there is in fact, according to paragraph 11, reservation of rights since the outset of this case. Its ability to protect this interest is impaired or impeded, and the interest is not adequately represented by the existing parties. Folks, I'm telling you, there was no disclosed witness who could have testified under United Fire's that was not presented by United Fire's chosen counsel. And Your Honor, there is a difference, because under the contractual duty under the policy, We think, I don't know why United Fire is not paying anything, just don't know. They have to know by now that this case is worth some kind of money. But in order to get the extra contractual damages, there would need to be a finding of bad faith. And so that's what the other lawsuit is about. And then finally, I have to ask the court that if you're going to remand it, please do it with instructions to the trial court so that the trial court knows exactly what to do, because again, this area is fraught with all kinds of problems. There could be all kinds of differences.
Mr.
And
Levy, I see that you're out
Yes.
of time.
Thank you very much for your time, Your Honors.
I only have 24 seconds, so I would
I'll
just
give you
ask-
an additional 15 seconds since.
Okay, thank you, Your Honor. I would ask the court to look at the record carefully regarding our positions. One, he mentioned that there was a reservation or we never said we provide coverage. There's a pleading in the file, reply in support of the motion for supplemental authority. We unequivocally say, United acknowledges that it is contractually obligated to cover any judgment against the named insured and driver for bodily injury arising out of the subject action up to the available policy limit. United's interest in this
What
litigation.
page of the record are you referring to?
It will take me a second.
That's fine.
I apologize.
And I see now that you are out of time, so
Should I tell you the record?
That's
site?
fine.
I apologize. I just asked the court review the record. There are a lot of factual disputes between what counsel said and I said.
all
Your
right.
Honors, I don't know if I'm allowed to do that, but I do object to that because their briefing was complete with many.
We don't have objections here. So thank you, counsel, for your arguments. The case will stand submitted and a written opinion will issue in due course. And that concludes the arguments for today's docket.
The court will be